We have a bit of a happy update to report because the case that we covered a couple months back of Mahendra Patel out in Georgia, close to Atlanta, where he was falsely accused of attempting to kidnap a child, has been dismissed. And we're going to go through the details and let you hear what the state had to say in their motion to ask the court to dismiss the charges. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. If you don't remember, there was a case a couple months back where an elderly gentleman named Mahendra Patel was in a local Walmart in Ackworth, Georgia. The allegation was that he had attempted to remove a male toddler from his mother's lap. It was nonsense from the beginning. And so if you haven't seen the original video, best thing I can do is just kind of give you the highlights of my original video, what was said, what was alleged, and then you'll be able to see the contrast between what the state alleged and the level of opposition the state had to even allowing the court to view the video and determine whether he should have a bond. He sat in jail for almost 2 months before he was even given a bond after a direct presentment to the grand jury and an indictment. And then the state put up a silly fight to try to keep the court from even viewing the video to determine whether he should have a bond. And then a couple months later, we have the state making its own motion to null pros, or nolly is what we call it in Tennessee, but basically to indicate to the court that they have no intention of seeking a further prosecution of this case. So without further ado, let's just go back in time to the previous video, and then we'll catch you up to speed with the new video for the dismissal. Let's check it out. What if I told you that a retired Georgia man with financial means to afford bond was arrested, jailed for 49 days without ever having an opportunity to have a preliminary hearing, indicted by a direct presentment, even though there was surveillance video that shows that the accusation was provably false, and that it was the same surveillance video that the police used to identify the man and ultimately secure an arrest warrant? Mahendra Patel, a retired real estate investor, walked into a Walmart in Ackworth, Georgia to buy Tylenol for his sick mother. He ended up having some exchange with a lady named Caroline Miller while he was in there. Miller was seated on a mobility scooter. Patel thought that she was handicapped. He ended up interacting with her for a couple minutes, asking her to help him try to find a particular brand of Tylenol. One of the kids in her lap was a toddler and reached out towards him, and Patel instinctively reaches to catch the kid and gently places him back in the mother's lap. Patel leaves the interaction, moves on, minding his own business, ultimately asks somebody else for help trying to find this Tylenol, and he finds it eventually. And then on his way out of the store, after having no more interactions with this lady or her children, he ends up seeing her and shows her, "Hey, I found the Tylenol I was looking for that I was asking you to help." She gives him a thumbs up, and 30 minutes later, that same woman calls 911 and claims that Patel tried to kidnap her child off of her lap in the middle of the Walmart store.
Did someone try to take you from Mommy?
Yeah.
Caroline Miller says it started when the shopper asked where he could find Tylenol at a Walmart in Atlanta.
It's over there. And as soon as I did that, that's when he just picked him up out of my arms.
What followed, she said, was a tug of war over the kid. She called 911.
I was in the Walmart and I had to rip my baby out of some other man's hands because he was trying to snatch him.
Someone trying to snatch your baby?
Yeah.
Now, you're probably thinking, well, James, I have complete confidence that the police looked at the video and was like, that didn't happen. Well, you'd be wrong about that, and I know that you didn't think that in the first place. The police took the case at face value, watched the man on surveillance video, identified him after they watched him get into a vehicle and looked at the vehicle plate, and then secured a warrant for his arrest a few days later. After his arrest, he was in jail for 49 straight days, being held with no bond, with no preliminary hearing, and charged for crimes that he didn't commit. Now, all of that might sound like your run-of-the-mill standard thing that happens to everybody, and it is a result of a Karen manipulating the circumstances in order to get attention and get a person arrested. Ordinarily, in a criminal prosecution, the way it works is that the police officer gets the warrant or makes a warrantless arrest. That person has an initial appearance, and then they have a preliminary hearing. And in Georgia, I think they call it like a committal hearing. And the purpose of that preliminary hearing is to have a judicial examination of the evidence so that a judge can decide, hey, there's something that merits sending this to the grand jury so that we can have a trial on this matter, or there's not. But the point is, a person would generally be afforded an opportunity to have a hearing where both sides get to sort of take an adversarial position on the evidence and present their case to the judge. In this case, that did not happen. Instead of the normal process, the Cobb County District Attorney, that would be Sonia Allen, decided to take the case directly to the grand jury. No early scrutiny, no challenge to the evidence. My question is, why? Let's be clear. This wasn't some covert investigation where secrecy was justified. Direct presentment, in my experience, is normally reserved for situations where there's some sensitivity attached to the circumstances. Things like major criminal investigations, RICO, corruption, murder, child exploitation, or SA, where the target doesn't realize they're even being investigated many times. This was a random man arrested at Walmart for a public incident caught on surveillance video. Now, you might wonder why it matters that the prosecutor chose to go with a direct presentment as opposed to the normal path. But again, the normal path affords the defendant an opportunity to have his case examined by a judge. A direct presentment does not. By proceeding to a direct presentment, the state never had to publicly show the video. And it turns out that all of this is completely legal. Apparently, Georgia lacks any sort of mandate on the amount of time a person can be held without bail prior to an indictment, with the exception of one statute. And it says in pertinent part, any person who is in custody charged with an offense that is not bailable, that would be the attempting kidnapping charge, shall be discharged from custody, meaning he's being released, if he is not indicted or accused within 90 days from the date of his confinement, unless the delay is caused by the defendant. Now, maybe you're thinking, okay, why does any of that matter? Well, it matters because it's a crazy way to treat an elderly retired man where there is actual evidence that preponderates against the allegation. And we happen to know that the police saw the surveillance footage because they used it to identify him. Now, this is what actually happened, but instead of me telling you or reading you some version of events that I crafted based on what I thought the police officer probably said, I'll just let you watch the attorney, Ashley Merchant, who is a badass, by the way, tell the judge when Mr. Patel finally got in front of a judge what actually happened and show the video along with the facts as they unfolded in real time.
He talked to at least 3 employees after this alleged interaction. So during this time that the police have said that he fled, he remained in Walmart for a full 8 minutes. He talked to 3 different employees, and he passed Miss Miller 3 times. He used his debit card, and then he waited at the door and talked to an employee for over 30 seconds. I'm going to show you if you want to pull up. So what we've done is we have a couple different videos. One of them, because nobody wants to watch 20 different surveillance videos, one of them shows Mr. Patel coming in, and if you want to go ahead and start playing that. And then I can show you the exact interaction.
If I could be heard. This isn't a trial to bond hearing, and so I would encourage the court to consider the legal bond considerations. I'm not sure that this is pertinent to that. If they want to submit this for the court's review, if they believe that they can articulate why it's pertinent to the issue of bond, which is the narrow issue we have today, I can understand that, and we can have that discussion. But if we're just playing videos to try the case in a bond hearing, the state would object to that. It's not relevant.
You have a relevancy objection.
Judge, I can't imagine anything that's more relevant than a video of the alleged incident. If you were trying to determine bond and you had a video of what the accused is accused of doing, that could potentially be the most relevant information you would ever have in a bond hearing, whether or not someone actually did what they're accused of. And the other thing is the state has alleged that he fled. That's been alleged from the beginning by the police. There's no, part of the bond factors, significant risk of fleeing or failure to appear in court. No. Is he a danger or a threat to anybody? You need to watch the video. He's not. He's clearly not. Is he at risk of committing any future felonies? No. I mean, I think it's highly relevant, and I would imagine the court would want to see this.
Well, I'll overrule the objection. As I read the pleadings, I looked at it as possible evidence that he would come to court and that he is not a flight risk. Of course, I haven't seen the video, right? So I don't know what it's going to show me, but I'll let you do that. And just so everybody knows, I have my own monitor down here. I'm not staring at the floor.
Wonderful.
I'll let you do that.
Thank you so much. All right, and this is the compilation. So the reason that we did this part is to kind of show the timeline. You can go ahead and play it. The timeline for the court when Mr. Patel enters the store at 8:16. And then you can see him walking, and he's on his phone, texting his daughter, which can be corroborated by the phone when we get it. Now you see him, he's walking to the pharmacy section. This is the pharmacy section. And now this is when he actually interacts for the first time with Miss Miller. So that's Miss Miller in the cart, in the scooter. It's the first time that they've met, and they're talking about the Tylenol. And so the gentleman, you can see a gentleman in an orange shirt behind them. That's the gentleman I was talking about. That's the witness. His name is Mr. Leva.
Right.
He's the one that later assists.
All right.
And witnessed the whole thing. So this is the other view, so you can see how close Mr. Leva is. And behind this display cart is that's when you can see the beginning of Miss Miller's cart. So the alleged incident is happening now. Here's the other view of it, flipping back so you can see both views. That's the alleged incident right there. Then she points. He moves on, goes to get the Tylenol. She backs up into the display cart. She's laughing, joking with this gentleman. This is literally a split second after this alleged kidnapping. You see her child kind of get off the cart. She runs over the child's foot. The guy jumps in to help. She was having trouble with the cart. I mean, everybody says that. All of this is after this alleged kidnapping has taken place. There's Mr. Patel entering the video again. You see him walking past. He talks with this guy that's witnessed this alleged kidnapping. Miss Miller's right there. Doesn't say a word. She's puttering along in her cart. He's chatting with this gentleman, asking about the Tylenol. This gentleman speaks Spanish, so the communication's a little bit difficult there. Mr. Patel goes to try and find a Walmart employee. He walks past Miss Miller again. There's that other interaction I mentioned, the third interaction, walks past her to find a Walmart employee. Again, this is all after this alleged kidnapping, so, he's not fleeing. Want to find another employee. There's the employee walking him back to the Walmart pharmacy to show him where the Tylenol is. So you can see Miss Miller puttering along in her cart in the back of this video. This employee shows Mr. Patel where Tylenol is. Miss Miller puttering along still on her cart. Mr. Patel walks past her, shows her, look, I got the Tylenol. She gives him a thumbs up. He keeps going. That's when, at 8:27, that's when she first told this Walmart employee about this. At the same exact time, Mr. Patel is paying for his Tylenol, so he's still in the store. And you can see if you zoom in, and we didn't do that, but it's the rapid release Tylenol. It's a special gel Tylenol that it's the exact same label that his daughter texted him a picture of to buy. And Mr. Patel has no medical background. It's not surprising that he's asking his family for help. His wife's a doctor. His daughter's in medical school. So, I mean, it's not surprising he's asking for assistance with this. Pays with his card in his name, linked to his bank account. I'm talking with this employee on the way out. Complete opposite of fleeing. I mean, he's like the typical elderly gentleman who talks to everybody at the store. And then he leaves. 8:28, 8:29, he leaves.
All right, so that should give you the overall general circumstances as to how we got here. And then now we're going to go over and check out the actual dismissal and the very short hearing that took place in order to get where we are.
If you're ready.
All right, the court will call for consideration that matter concerning the state of Georgia versus Mahendra Patel, case number 25 CR 01090. The record can reflect the matter was set by the court on the state's motion pursuant to OCGA section 17-8-3. The record can reflect that Mr. and Ms. Merchant are here representing his interest. Do you waive his presence?
He's
or is he
actually
here?
present in the courtroom with his family.
He's here someplace?
Yes, he is. Thank you, Judge.
All right. And Ms. McCauley's representing the interest of the state. She's the one that filed the motion. And I've read the state's bench brief and the motion, and I'm ready.
Thank you, Judge. I'm not going to be overly repetitive of what is already provided in the state's motion, which was filed this morning. The state is making a motion pursuant to 17.8.3 of the official code of Georgia for an entry of null pros as to the following. The district attorney's office for the Cobb Judicial Circuit and Mr. Patel, along with his counsel, Caroline Miller, on her own behalf and on behalf of the minor child, consistent with her election under 1717.1 at SEC, met to discuss their respective views of the above captioned case. That was done on Monday of this week. That election was done after a thorough review of all available facts and circumstances, evaluation of the best interests of the community and goals of the criminal justice system. After both that review and the parties' discussion of their respective positions, the state is satisfied at this point that the ends of justice have been met, and we would move for an entry of null pros.
Merchant?
We have no objection, Judge. Thank you.
All right. I believe it's in the court's discretion, and obviously that's fine with me, knowing what I've seen in the matter. I appreciate the state looking into it. You've complied with the Victims Notification Act by speaking with the alleged victim in the case.
Yes.
And I'm satisfied. If you present the null pros, I will sign it.
Thank you, Judge.
Null pros has been entered in the Patel case.
Thank you, Judge.
Thank you, everyone. That'll complete the hearing on Patel. We'll be in recess until we have some pleas ready. Do y'all want to talk with me about that other case?
Okay, so as you can see, the state, serves the ends of justice, all that stuff, right? In other words, look, we have no way of proving this case. The truth is this: probable cause gets overcomplicated in the way that people try to make it work. There's a whole lot of mental gymnastics that goes into probable cause, but it basically comes down to this: every law, every statute has essential elements. The essential elements of a burglary are generally that a person entered, right? Entry is an essential element. The property of another is an essential element. In common law, burglary was at night. That's an essential element. And with the intent to commit a felony inside was an essential element at common law of burglary. All of those things are essential elements. In order to establish probable cause, it really comes down to a matter of exploring probabilities. Is it more likely than not? It's literally just is it more probable than not that a crime was committed and that this person committed it? That's all it really asks. But what people don't understand, and by people, I mean police officers investigating probable cause, don't seem to understand, is that the calculus into the probabilities has to take place on every essential element. And, just like in our previous hypo, a burglary. Well, is it more probable than not that the person entered at night? That should be fairly easy to figure out. Is it more probable than not that this person entered the property of another? Well, that's an essential element. You have to undertake the calculus on every single element. Well, when it comes to kidnapping, we have to look at whether or not the evidence available to us at the time that we're making this investigation indicates that this person had the required mental state that he wanted to try to take this child from his mother. And every single thing about his behavior indicates that that mental state is just not present. And that was an actual factor that the court had to consider in the bond, was whether or not this person actually did what he's accused of doing. And if you watch the video and if you pay attention, it should be obvious to anybody who doesn't already have a predetermined outcome that they're trying to reach, that that is just not what happened here. This guy, nobody who tries to steal a kid anywhere, but certainly, and look, there's issues with people trafficking children. It's not like it's something that we don't have to deal with in our society. It's certainly something that is a problem, but I would bet every dollar on my bank account that in every single case where a child's been abducted, we could just take Walmart's or public shopping malls or wherever, every single case, I bet what we don't have is the guy hanging around talking to every single person in the store, putting himself all over the video camera, going back to the person whose child he just tried to steal and being like, hey man, I found the Tylenol I was looking for. Thanks for your help. Like, none of the things that this guy did were consistent with the things that a person who was trying to abduct a child and failed at doing that would have done under similar circumstances. And so that's why everything about this screamed, at a minimum, the case could not be proven, even for probable cause. And he has a civil action for a 1983 unlawful arrest case, in my opinion. And it's not just my opinion. We can go over to the interview that Ashley Merchant, the defense attorney, had with Jesse Weber from the Law and Crime Network and hear what she had to say. And if you pay close attention, she'll signal to you what their future intentions are. Let's check it out.
I am pleased to welcome back here on Sidebar Patel's defense attorney, Ashley Merchant, as well as her investigator, Charles Middlestat. Thank you both so much for coming on. Congratulations. This is a huge win. I mean, Ashley, last time you and I spoke, I got to say, what you were telling me about the surveillance footage and what it shows, I'm not surprised by this outcome. I mean, it took a little while. Obviously, Mr. Patel was saying how he and his family went through hell for this to actually get to this resolution. How is he feeling right now? What kind of impact has this had on him and his family?
Yeah, that's a great question, Jesse. He is just thrilled right now. But, we had him sort of put together a statement about how it impacted his family, and reading it just really upset me, because he's got two very successful, wonderful daughters. He's got a very close family. He cares for his mother. His wife cares for her mother, and just the impact on all of them. I don't think people realize how impactful it is when someone is taken from their lives for 40-something days without warning, and how it impacted all those other people. He's got such a wonderful outlook about everything. He's so much more positive than I am. He's like, oh, the system worked, I'm free. And I'm like, no, the system failed you. You were in jail for almost, 2 months. But he is much more positive than I think most people would be under this circumstance. But he's very happy that it's finally behind him, at least the criminal charges, and that he can close that chapter.
But before we wrap things up, Ashley, just jumping on something that you said at the beginning, you basically said that Mr. Patel has finished the criminal case, right? The criminal case is put behind him. What about the civil case? Is he considering taking any sort of civil action, any sort of legal action, and who would that be against?
Well, we always keep all of our options open. How we operate is we always want to resolve a criminal case completely and successfully, and we don't want to cloud our judgment on a criminal case with the thoughts of a civil case, because that's very difficult. But there are a lot of actors here that things that were wrong and took significant liberties that caused harm to Mr. Patel. So, we're always going to evaluate those options. We don't have any concrete plans, I can tell you at this point, but we are not leaving Mr. Patel. We've all become very good friends with Mr. Patel and his entire family. He's a great guy. And so, we're going to keep all those options open.
So, in closing, I'm very happy that this case was dismissed. It never should have been brought in the first place. I believe that Mr. Patel will have a successful 1983 lawsuit for false arrest under the circumstances, because I just don't think it rises to the level of probable cause. And I think that the actions of the state are telling that it would not rise to the level of probable cause. And here's why. They were able to bypass judicial scrutiny by not allowing Mr. Patel to have a probable cause determination in front of a judge. They went straight to the grand jury. They presented the facts exactly like you would need to present them in order to get an indictment. They stuck him in jail for 49 days. And the only time that anybody ever decided maybe we should ask ourselves whether the probability exists that this guy did this beyond what we could submit to the grand jury from an intentionally one-sided framed narrative that we could offer without opposition, and let somebody actually examine this. The first time that happens, he gets a bond, he gets out, and magically 2 months later, well, we can't prove the case. Isn't that a miracle? The truth is, it should have never been prosecuted. It should have never been presented to the grand jury. If they were going to arrest him, they should have filed a warrant, had a judge sign it for probable cause, and sent him through the preliminary hearing stage so that a judge could have determined whether there was probable cause to move this forward to the grand jury in the first place. They didn't do that. Because of that, I think there's the potential that there's a malicious prosecution claim out there, depending on what they can prove, and certainly an unlawful arrest under 1983, because this case, if I've ever seen one, lacked probable cause, and the evidence was right in front of their face the whole time. So I'll keep you informed as this thing changes. If he does end up filing a 1983 suit, I think that's what Ashley was signaling when she gave her remarks to Jesse. But you have to remember that she practices criminal defense in that community. Going on national television and threatening to sue the Cobb County DA is not the way to make sure that you get fair dealings for all the rest of your criminal defense clients that you currently have to service and you have obligations to. And so she was smart to keep that close to her vest. But I do think there's going to be a lawsuit, and I do think he's going to win. And when that happens, we'll certainly provide you with an update. So just wanted to let you know the good news. The case has been dismissed. We're moving on. If anything comes up in the comments, I'll write a Substack blog post to sort of fill you in on what I missed. I'd like to invite you over to Substack. It's absolutely free to join. That's a newsletter site that I give some of the behind the scenes stuff, some of the stuff that I didn't know at the time that I published the video. Whatever comes up, I generally will write an article about it and supplement the video in that way. You can join on a paid tier of Substack if you'd like to, but that's only for people who want to support the channel monetarily. I don't put anything on Substack that people have to pay for. If you don't want to go to Substack, but you'd still like to support the channel monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.